Okay, so these are very, very difficult hearing questions. You might hear one of these in your hearing. However, it's unlikely you will get one that is this difficult, but sometimes they come out. Sometimes when it's a particularly difficult claimant or is making the judge feel like the judge needs to do more, there's always that type of claimant. These are the 5 extreme disability hearing questions that I want to teach you guys and walk you through so that you have an understanding as to how to deal with them. Number 1, which job would be the easiest to return to over the past 15 years of your work? Now, look, obviously, this is a trick question. I'll read it to you again. Which job would be the easiest to return to over the past 15 years of your work? So this sounds pretty straightforward. Sounds pretty, pretty easy to answer, right? Oh, that was the job at Chuck E. Cheese. That was the job at the adjuster place, or that was the job at the this or the that. Here's the problem with that. You are then putting on the record that A, there was an easy job that you would be able to potentially return to. And the thing that you're not going to include is why you wouldn't be able to return to it. That's why we have cross-examination with attorneys. But the point is, if it's just a claimant in there on their own, what they'd say is, oh, easiest job to return to would probably be when I was working at that dental office just doing reception work, right? That's, pretty straightforward, got it done. Yeah. What you've told the judge then is that this job existed. You have the potential of going back to it. So the follow-up question you're probably going to get from the judge is, well, why haven't you gone back? Now, this is where the claimant needs to do an amazing job. The judge may not ask that, in which case that's not a good situation for the claimant. But if the judge asks, well, why don't you go back and work there? You better have a good reason other than, I don't want to work. It's hard for me to work. Those are terrible, terrible answers to a really difficult question. You have to be able to explain in detail the functions of that job and why those functions would be difficult for you today. But you have to keep in mind that the judge is sitting there with an IRS readout of all of your other jobs that you've had within the past 15 years that are relevant as part of the 5-step sequential process. And the judge is then going to say, wow, that job sounds like you had to do some tough stuff. I mean, what about this other job? Was this job easier or more difficult than the job where you worked at the doctor's office, the dental office, whatever? And then the judge is starting to peel away the onion on how likely you are to be truthful about essentially how difficult these jobs were. Because somewhere at that point, when you describe why it would be tough for you to go back, that's where the judge is really earning, essentially whether or not you're going to be a truthful person with future questions coming up. And that's a tough thing because you're asking the claimant to do a balancing test, right? More difficult jobs, less difficult jobs. Which of the past 15 years was a more difficult job? Now, a lot of claimants right off the bat, to be fair, don't even remember what their jobs were within the past 15 years. So I've seen this applied where the judge will go through the jobs that were all SGA plus, and then from those ask the claimant, well, which was the easiest job out of all of them? That's a very, very tricky question because it leads to a lot of potential questions thereafter that can get the claimant in trouble and make them seem less truthful. Number 2, which job would you be most likely to return to if the disability benefits were denied? Some people will answer it the easy way. They'll say, well, I can't. I am not able to work. I can't return to a job. And that's an okay answer. It's an okay answer. I mean, you should put a little bit more to it than that, but it's an okay answer. What you're really looking for here is a claimant that can say, well, the 3 longest jobs that I had were this job, and this job. And I wouldn't be able to return back to those jobs because of A, B, C, D, E, F, and G. So as a result, if I were denied disability benefits, I would not be able to work any of the prior work history that I've really known that were with substantial, gainful earnings over the years. Okay. So that's a tricky one. I don't think answering it as I just won't be able to work. I don't think that's a great answer. You should take it to the next level of explaining the last 3 jobs that were the longest jobs, highest earning jobs, whatever, why you wouldn't be able to do those jobs. Okay. Give a little meat to the answer. That way the judge has something to use when they write their brief. Number 3, If you reduced your hours at one of your jobs, but were still above part-time, would you be able to continue working? Now, this question is extremely difficult because A, it's saying, hey, we don't expect you to do a full 40-hour week, but we expect you to do an hour more than 20 hours. And if you're working more than 20 hours, you're above that part-time labor situation, and you're probably going to be earning, obviously, over SGA, substantial gainful activity. So what they're really asking here is, and I'll read it to you again, if you reduced your hours, you chose to reduce them because of your impairments at one of your jobs, a job that you've had within the past 15 years, but we're still above part-time work. So you're working above 20 hours, you're at 21 plus hours. Would you be able to continue working? So if you reduced your hours at that job you used to have down to just above 20 hours, would you still be able to do that job, or would you have to quit? In which case you should be saying, my employer would not give me the accommodation of reducing my hours further. They need somebody to do the job full time, beyond just 21, 22 hours. Additionally, and this is where you go into basically, the next thing, I was unable to find alternative work because of, that's where you outline your impairments, which require me to be able to do, and that's where you outline specifically the functions of those jobs. A lot of people, though, would answer this the following way, which you don't want to do, but I'll give it to you either way. If you reduced your hours at one of your jobs, but were still above part-time work, would you be able to continue working? This is how a claimant shouldn't answer, but I'm going to give you how they, I get claimants that answer things like this in the beginning before we start going through stuff. They'll say, well, yeah, I could probably, if I only had to work like 25, 30 hours, I had like an extra day off or something, I could probably continue to work. Or they'll say, well, if they cut my hours down, it wasn't so stressful. I'd probably, if I had that extra time, be able to, get to the office and continue working. And that's deadly. That's deadly because then the judge has essentially SGA level work above part-time work, and they're going to start to play with that. And you don't want them to be able to play with that scenario. That's why that's an extremely difficult Social Security disability question. Number 4, what's an example of a lower level job title that would be easier for you to complete of the jobs you used to work? All right, this is a scary thing for claimants, and they have no idea why. What happens with this question is, what's an example of a lower level job? So, right, if you were a doctor, then you were a physician's assistant, then you were like an ARNP, although that's, whatever. But then you go to a nurse practitioner, then you go to like, medical intern, whatever. You just keep going down the level of jobs, right? All the way at the top, you've got double board certified postdoctorate specialist, regular specialist, physician's assistant. And you just keep going down farther and farther into the levels of a particular job, right? So we're thinking in the hierarchy of jobs. You used to be boop up here, but now they're asking, could you do a much simpler job down here? So let me read you the question again so you can hear it. What's an example of a lower level job title that would be easier for you to complete? This is a very, very tricky question because you're right off the bat answering that you could potentially do a job because it would be easier for you to complete, which is not good. You have to be smart enough to know to say, okay, I was a physician and I could do a nurse practitioner job, but I couldn't do it well enough to continue to keep up the standards of the licensing requirements for the following reasons. But most people who have zero training are not going to know that. Most people are going to say, well, I guess if I was, the bowling alley owner, I could just be like a person who just does cleaning around the bowling alley. Maybe I could do that. That doesn't involve as much this kind of labor, that kind of labor, ordering parts, long days, long nights, stuff like that. You don't want to get stuck where you're admitting to a different type of job that you could potentially do. You want to explain as the disabled person that what you're claiming you are, that you cannot do these other jobs because of A, B, C, D, E, F, and G. Number 5, what job functions could be removed from your past work so that you could continue to do that job? All right. So this is another trick question. The reason it's so difficult is because you are creating a job that probably doesn't exist in the DOT, but it tells the judge why you were limited in your ability to work at that job, whether you got fired or you quit. And what it tells the judge is, okay, this is what the claimant had the most difficulty with. So, what other jobs out there exist that do not require those things, but have all the other stuff, or most of the other stuff, or some of the other stuff that the old job required of the applicant, of the claimant? So I'll read it to you again. What job functions could be removed from your past work so that you could continue with that job? So put another way, imagine what the judge is saying is, all right, look, if we took out you having to lift up heavy garbage bags, having to move the garbage outside, having to, basically move and unstack in place the food trays, there's a lot of them, off of the truck into the back room area. Look, if we took that out, you didn't have to get here, right on time every time, had a little bit of wiggle room. If you didn't have to deal with the general public as much, could you still do that job? And what the judge is doing, and this is the higher level ALJs, the ALJs that do this kind of stuff, like, they enjoy their job. They like, this is part of their like giggles and wiggles, But the point is this: when you outline for them taking away certain job functions, right? The judge is thinking, okay, what other jobs are like this job but do not require those things? That's the exact same thing the vocational expert is sitting there thinking as well during the hearing. Now, you can really do a great job with this question, and you can outline the most basic fundamental functions of those jobs and why you can't do them. And that will kill off lots of jobs in the DOT that are at least, transferable skills maybe, or similar in some way, fashion, or form, or whatever. But the goal here is, what job functions? They have to be the most basic. They have to be the most simple functions. Otherwise, if you're talking about the highest level functions, they'll get rid of those and look at jobs that potentially you could do that are lower on the totem pole that do not require those higher level functions. So the best way to approach this thing is to go ahead and talk about the base fundamental functions: walking, standing, pushing, pulling, kneeling, lifting, crouching, stooping, etc. You got it. And that's just the physical ones. There's mental ones as well. All right. These are 5 extremely difficult disability hearing questions that are very tricky. I'm going to read through them one more time for those who just joined us, and then I'm going to pop out and get working outside. Which job? Okay, so this is question 1. Which job would be the easiest to return to over the past 15 years of your work? Number 2, which job would you be most likely to return to if the disability benefits were denied? Number 3, if you reduced your hours at one of your jobs but were still above part-time work, would you be able to continue working? Number 4, what's an example of a lower level job title that would be easier for you to complete? Number 5, what job functions could be removed from your past work so that you could continue to work at that job? All extremely difficult questions that a lot of claimants would have a very difficult time with. Please remember, guys, that I make these videos in part because I want the community to understand the realities of this stuff. Yes, my phone's going off somewhere. I don't know where it is. Yes, I do get paid to make these videos. Not as much as I used to, because YouTube now has a system where people have to pay for their videos to show up in the search results as like suggested videos. So everything just took a super dive for the amount of views, and then they expect you to pay to basically put your videos more up there. So I am going to be looking at the option of doing a live show on Facebook. So we'd have one live show on YouTube, which would be the Thursday night, and then maybe like Tuesday night would be Facebook, and then we do one there. The point is, I've been a little disheartened with YouTube and the way they're changing things for creators, because they want creators to make a lot of product, a lot of videos explaining whatever, whether they're jumping off a bridge or you're learning about the legal, problems that you can face while getting disability benefits. So I'm going to be going and looking at all these other options when it comes to other platforms. One thing I do want to say, that if you do go ahead and like and subscribe, when you subscribe, make sure you hit the little button if you want to see mine, because you're not going to really see many of them unless you do the little ring the bell option. The other thing to keep in mind is that one of the big things that helps me out to show continuity and excellence and, just doing a great job with disability claims are those 5 stars. I always appreciate waking up and seeing those. You can leave whatever review you want, but I always like to wake up and see the 5 stars on Google. So you just Google Disability Resolution Law Firm, Disability Resolution Florida, and then hit the write a review button. Finally, with that said, today I'm just finishing up the contract. We did do a prototype on the hourly situation, which is for claims I can't take, for claims that can't get a quick answer in that Thursday night live, where I go live on Thursday and just answer questions. Like anybody can call in, I answer them for free. Where they need more than that, like they got a CDR coming up and things are looking a little hairy, or they've got a hearing coming up and they can't get a hold of their attorney, or they don't even have an attorney and I can't take their claim for whatever reason. You can always hire me for an hour. It's not before the SSA, meaning I'm not representing you before the SSA, and the staff doesn't get involved, and it's just for 1 hour. So that whole system is going live basically tomorrow. And then the prototype that I had with the person where I did it, it went well, but I think I overloaded them a little bit. I think I scared them a little bit. But to be honest, though, that's part of the $250 is like the deep knowledge. Like if you want to know and you want to get something deep, then if you give me an hour, I will give you the scary stuff too, whereas this is like we get, a short period of time. We got 16 minutes on the clock and I'm giving you 5 questions that are scary. And the reason I'm doing that is that one of them popped up recently, which is, I'm not going to say which one because I like to let a little bit of time go by so that the claimant who is part of it doesn't watch the video and go, oh my God, that's me, But the point is, there's so much stuff and each claim is so unique, but I will catch you a little bit later. Please, please, please have a wonderful, wonderful night. I'm going to go weed whack. And then basically I'll finalize the contract details on that, and we'll be doing that tomorrow. Okay. I will catch you later. Please take care of yourself and have a wonderful night. Thanks so much, guys. Bye-bye, guys. Bye-bye.